In this installment of Washington Legal Foundation's Legally Brief, Michael Sclair, a partner with the Williams Mullen Law Firm and a former Assistant United States Attorney, examines the challenges business organizations must confront in the face of parallel civil and criminal federal enforcement activity.
Companies that work in highly regulated industries, such as the financial industry, are increasingly confronted with dual enforcement actions on the civil and criminal side. An agency such as the SEC or the EPA will conduct an investigation at the same time that the Department of Justice opens its own criminal investigation. The dual fronts pose significant challenges for corporations and their attorneys on legal issues, such as invoking the constitutional right against self-incrimination, which will help with the criminal side, but may result in a negative inference on the civil side. In a practical sense, parallel investigations raise issues concerning payment of fees, corporate representation, and whether to self-report and receive the benefits of cooperation. In this environment, the traditional white-collar criminal lawyer must be experienced civil litigators, and traditional securities and commercial litigators need to be well-versed in criminal issues such as the McNulty and Phillip memoranda and the sentencing guidelines. Up until April of this year, federal courts had been increasingly critical of the government's conduct in parallel criminal and civil investigations. For example, in 2006 in United States v. Scrushy, the Northern District of Alabama suppressed statements of a criminal defendant given in an SEC deposition because the government misused the testimony to obtain evidence in the criminal prosecution. Also in 2006 in United States v. Stringer, the District Court in Oregon dismissed an indictment against 3 individuals because the U.S. Attorney's Office and the SEC had an arrangement where the SEC conducted an overt investigation and the Justice Department worked behind the scenes on its criminal investigation based solely upon the SEC's work. The court described the conduct as, quote, trickery and deceit, particularly where the SEC lawyer instructed the court reporter not to mention the involvement of a DOJ prosecutor. This spring, however, the Ninth Circuit reversed the Oregon court's ruling in Stringer, holding that there was no due process violation because the SEC had independent authority to conduct investigations, because the SEC conducted its investigation not solely to obtain evidence for the criminal prosecution, and because the witnesses appearing before the SEC received both written and verbal notice that their information could be used in a later criminal proceeding. The court found that the SEC and DOJ had not acted in bad faith and held that only upon a showing of bad faith would the case be dismissed. There are several lessons to be learned from the Ninth Circuit's decision in Stringer. First, when faced with a civil regulatory investigation, counsel must always analyze whether there exists or could exist a criminal case and understand the Fifth Amendment implications of providing statements and documents. While a corporation has no Fifth Amendment right, the individual employees may assert the right, and providing documents or testimony may implicate the privilege, and the client may seek active production immunity. Counsel should always ask the agency counsel whether DOJ is conducting a parallel criminal case and should try to obtain communications between the agency and DOJ. While counsel has no affirmative obligation to answer that question, the case law seems clear that the government cannot mislead. These communications may form the basis of a challenge for bad faith. Second, counsel should attempt to stay the civil proceeding pending completion of the criminal investigation to avoid any constitutional issues. Third, counsel should always engage in a global resolution that resolves all outstanding investigations. Do not make a deal with the SEC until agreement has been reached with the United States Attorney's Office. Finally, always be aware of the likelihood that private civil litigation, whether through a shareholder or class action lawsuit, will follow the enforcement action, and so any admissions and waivers may be adverse in the subsequent proceeding. As we've seen over the past several years as a result of budget cuts and the needs of the war on terror, law enforcement agents working on white-collar matters will continue to work hand in hand and rely upon their agency counterparts to make their cases. Since the courts are likely to side with the government absent indicia of bad faith, the bottom line is that counsel need to be ever vigilant to ensure that their clients' rights are adequately protected and that they are not punished for their cooperation.
To learn more about parallel civil and criminal enforcement activity, read Washington Legal Foundation's special report, Federal Erosion of Business Civil Liberties, which is available on WLF's website, www.wlf.org.